The Supreme Court's apportionment decisions. In June 1964, the Supreme Court ruled that states must reapportion for state elections so that both houses of state legislatures will be elected solely on the basis of population. This decision, if permitted to stand, will virtually destroy existing forms of government in a majority of states. Supreme Court Justice Stewart, dissenting, calls the court decision a barbarously severe pronouncement which finds no support in the Constitution. Supreme Court Justice Harlan, dissenting, says the court illegally arrogated to itself the power to amend our Constitution, and that such unconstitutional decisions will destroy our federal system. The remedy against Supreme Court usurpation of power lies in Congress. On August 19, the House passed the Tuck Bill to apply that remedy. The public should persuade the Senate to pass the Tuck Bill. That is a summary of my report on the Supreme Court's apportionment decisions. The full report after a message from my sponsor. One essential principle of our constitutional system is that the Constitution is a binding contract to be obeyed explicitly by all agencies of the federal government. If the President and Congress believe the federal government should do something, the government cannot legally do it, no matter how urgent the need for the action may seem to be, unless some provision of the Constitution clearly authorizes the action. If for any purpose whatever, even if in response to the demands of all the people, the federal government acts without clear constitutional authority, then we have unauthorized, lawless government. If Congress enacts a law which is challenged as unconstitutional, the Supreme Court has no authority to consider the merits or demerits of that law, or to determine whether the law would be good or bad for the country. Legally, the court must restrict itself to determining what the constitutional provision in question meant at the time it was written and adopted to the people who wrote and adopted it. The original intent of a constitutional provision must be determined by the original historical records of that provision. If the historical records do not obviously make clear that the federal government had specific constitutional authority to enact the challenged law, then the Supreme Court must, if acting within the limits of constitutional authority and duty, declare the law unconstitutional, because the federal government is limited to clearly enumerated powers. What is the remedy if the Constitution does not clearly authorize federal action which the people desire? The only legal and safe remedy is for the people, acting through processes specified in their Constitution, to amend the Constitution and give the federal government clear authority to do what the people want it to do. What is the remedy if the Supreme Court hands down a wrong constitutional decision in a case where it has no valid jurisdiction, clearly violating the original intent of the Constitution? The proper remedy in that case is an act of Congress, withdrawing from the Supreme Court appellate jurisdiction in the case it wrongly decided, and prohibiting it from hearing any similar cases in the future. Congress has constitutional authority to limit or abolish the appellate jurisdiction of the Supreme Court. It has exercised that authority in the past, and the court has obeyed. Another essential principle of our constitutional system is that the individual states, while surrendering some of their sovereignty as independent republics in order to form a more perfect union, retained their sovereignty in most internal affairs and retained all of the broad, unspecified powers of government. Except in a few kinds of cases clearly covered by provisions in the federal Constitution, a person who feels abused by an action of his state government can get no legal constitutional relief from the federal government. For more than a century, the Supreme Court held steadfast to this constitutional principle, consistently holding that it had no authority to review actions of state governments. In many cases, the court admitted that the state law in question was bad and conceded that the persons bringing suit had been abused, but rebuked the complainants for bringing such cases into federal court, explaining that their only proper legal remedy was political action in their own states, warning that no state law, however bad, could be as harmful to individual liberty as the harm that would result if federal courts overstepped the bounds of constitutional authority to supervise state legislation. Another essential principle of our constitutional system is that political power, dangerous if concentrated in any one person, body, or agency, must be scattered and balanced. Political power was scattered among state governments and the federal government, and the limited federal power dispersed into 3 separate branches. Most of the federal power was given to the legislative branch, and this legislative power was divided into 2 separate houses of Congress, the power of one house checking and balancing the power of the other. All states, regardless of size and population, have equal representation in the United States Senate. Each state has at least 1 representative in the House, regardless of population. Beyond that, a state's delegation in the U.S. House of Representatives is determined by population. Hence, in elections for U.S. senators and U.S. representatives, there never has been equality of voting power for all voters in the United States. For example, the 1960 census shows a population of 226,167 for Alaska, 16,782,304 for New York. Thus, every Alaskan voting for a U.S. senator has 75 times as much voting power as a New Yorker voting for a U.S. senator. Most states have this same kind of apportionment for the election of their state senators and state representatives. The states are divided into districts in such a way that no district is entirely without its own representation in at least 1 house of the state legislature, regardless of population. Many states do have apportionment arrangements for elections to their state legislatures that are out of date, some absurd. For many years, individuals or political groups in various states have sued in federal courts, trying to force reapportionment within the states for state elections. For many years, the Supreme Court properly held that regardless of how inequitable any such state apportionment may be, the federal courts had no constitutional authority to intervene in such internal political affairs of the states. In 1962, the Warren Supreme Court struck down this constitutional barrier against federal encroachment, as it has torn down practically all other constitutional barriers against the illegal mushrooming of federal power. On March 26, 1962, the Supreme Court in Baker v. Carr ruled that federal courts did have jurisdiction to order the state of Tennessee to reapportion election districts for state elections. This decision, as Earl Warren himself says, encouraged a spate of similar cases to be filed in federal courts. On June 15, 1964, the Supreme Court ruled on 6 legislative apportionment cases involving Alabama, Colorado, Delaware, Maryland, New York, and Virginia. Earl Warren, writing the main opinion for the majority, ruled that a state apportionment which does not provide for representation in both houses of the state legislature solely on the basis of population violates the Equal Protection Clause of the 14th Amendment. Warren indicated that the apportionment must be arranged to give equality of voting power for every voter in the states, so that thinly populated districts could not elect as many state representatives as populous districts. This decision, if permitted to stand, will destroy existing forms of government in a majority of the states. It outlaws for states the same kind of balanced bicameral legislative systems that the federal government itself has. It leaves federal courts with undefined license to intervene in state elections. Supreme Court Justice Potter Stewart, dissenting, called the apportionment decision a barbarously severe pronouncement which finds no support in the words of the Constitution, in any prior decision of the court, or in the 175-year political history of our federal union. Supreme Court Justice John Marshall Harlan dissented in even stronger language, saying that the court had illegally assumed the power to amend our Constitution, and that such constitutionally impermissible court decisions will destroy our federal system. On August 19, 1964, the House of Representatives exercised its constitutional authority and duty with regard to the Warren Court's apportionment decisions. The House passed the Tuck Bill, introduced by Representative William Tuck, Virginia Democrat, which says in effect that federal courts have no jurisdiction in cases involving legislative apportionment in the states. The Tuck bill is now before the Senate, where it is expected to be buried or ignored by liberals. The Senate should be stormed with demands to pass the Tuck bill, because the Tuck bill is the proper constitutional remedy. Both presidential candidates should be pressed to take a clear stand on the Tuck bill this year, both Barry Goldwater and Lyndon Johnson. The roll call votes of congressmen on the Tuck bill, extensive excerpts from the dissenting opinions, and other details on this vital matter are in the published report on which this broadcast is based. For many years, people have been asking what can be done to curb the Supreme Court, which has become an oligarchy beyond the reach of the people, an oligarchy which illegally assumes the power to amend our Constitution and rewrite our fundamental law, making the Constitution meaningless by claiming it means anything a majority of justices want it to mean on any particular day. The remedy has always lain in Congress. Congress has clear constitutional authority to limit or abolish the appellate jurisdiction of the Supreme Court, and the Tuck bill does just that with regard to legislative reapportionment matters. If you have been wishing you could do something about the Supreme Court, here is your chance. Familiarize yourself with this matter and help create the public opinion to compel Senate passage of the Tuck bill, which has already passed in the House. Goodbye. God bless you. For the documented text of this broadcast, send 25 cents to Dan Smoot, Dallas 14, Texas, and ask for 471, the Supreme Court's apportionment decisions. 6 copies, $1.